So, dear friends, let's resume the conference with a second section which will be devoted to the legal standards on the immigration detention of children as set out by different international bodies. So this panel will be very legal, and it will be my pleasure to give successively the floor to Ms. Power-Forde, a former judge of the European Court of Human Rights, then to Ms. Kirsten Sandberg from the Committee of the United Nations on the Rights of the Child. Then we will have a speaker from America, from the Inter-American Court of Human Rights, Ms. Romina Sijniensky. And of course we cannot avoid speaking about Europe and the EU of 28 and maybe tomorrow of 27, we will see. Ms. Tuite from the European Commission, who is the coordinator for the rights of the child. And we will also have comments from a member of an expert group of the Council of Europe, of a committee of experts on administrative detention of migrants, whose task is to codify the rules or the standards about the administrative detention of migrants from the Council of Europe. So it will be a very rich panel, and I will not linger on anymore and give the floor immediately to Ms. Power-Forde, and she will present us the case law of the European Court of Human Rights. Ms. Power-Forde, you have the floor. Is everything ready?
I think so.
Great.
Good morning. It's a great pleasure, it's a great honour for me to address such a distinguished gathering here, and I would like to begin, as others have, by paying tribute this morning to the Ministry of Justice of the Czech Republic for taking leadership and courage in confronting a controversial and disturbing reality concerning the detention of children, of migrant children. The Council of Europe, as you know, was established in the wake of the Second World War, and never again was its major theme. Never again would people be confronted with such an affront to human dignity, such gross violations going unchecked, and never again would images of children in detention and other horrors be repeated. But of course we know that notwithstanding our courts and our councils and our committees and our commissions, the embarrassing truth is that on our watch we are witnessing the unfolding of one of the worst humanitarian crises to have occurred on the continent. Images of children in detention have not gone away. When I was on the Court of Human Rights in Strasbourg, one of my earliest impressions was that the court struggled when dealing with some of the most serious alleged violations of human rights. Many of these made their way to the court in the form of Rule 39 applications for interim measures made by people who were desperate to halt their return to countries like Afghanistan, Iraq, Somalia, and the Democratic Republic of Congo. Where children were involved, I found these cases particularly difficult when they were rejected, I won't say almost routinely, but certainly in huge numbers. However, when cases did succeed in working their way through the court, through the filtering system, the court's attention to the unique position of children has to be acknowledged. Recent research on the vulnerability of children published by the University of Amsterdam demonstrates that upon reviewing 500 cases of the court that deal with this concept of vulnerability, detainees form the highest number. After detainees, there are children, and after children, we have asylum seekers, migrants. So where you have a situation where the person in question is both a detainee, a child and an asylum seeker, his or her vulnerability has to be augmented and compounded. So such a person takes up the three top categories when it comes to vulnerability in the court's case law. And before turning to the question of detention of children by the state, I think we have to remember that one of the offshoots of this current crisis is that many children are detained not by the state, but by private individuals who are exploiting the children for a number of purposes. And trafficking involves, in many cases, the detention of children. And just to note that the court has made observations in this regard in Silidian and more recently in the case of Chowdhury in Greece. The court has pointed out that the penalisation and effective prosecution of any act aimed at maintaining a minor in a situation of forced labour, in a situation of having been trafficked, such a situation requires the state to act in such a manner as to prevent this type of situation occurring. States have a positive obligation to be cognizant of international law rights of children, and there must be state protection in the form of effective deterrence against such serious breaches. Now, we all know the reality of the current situation, and I have to say, we know that under the Geneva the Refugee Convention and the Dublin Regulation, those seeking asylum must do so in the first safe country, as it were. But that places a huge and, in my view, an inequitable burden on coastline countries like Greece and Italy. And to take just one example, Human Rights Watch report of July of this year pointed out that there was a huge increase in the number of children who were being detained. It said in July of 2017 there were 117 children in police custody awaiting transfer to a place of detention. And they also pointed out that a fear of being detained, of course, prevents many children from actually registering. It might be no harm just to recall generally the principles of the court when it comes to detaining minors before looking specifically at its case law in relation to the detention of immigrant or migrant children. The general principles are, of course, that there must be a convincing demonstration of the need for detaining a minor. I won't cite each case, it's cited there in brackets. The conditions of detention for a minor must respect their human dignity, and the ill treatment of any young person in custody will constitute, obviously, a violation of Article 3. The court case law confirms that minors enjoy enhanced protection than their adult counterparts. There must be legislation that dissuades offences against minors, and states have a particular obligation to ensure that where complaints emanate from minors in custody, that they are properly investigated. Indeed, it was in a child detention case that the procedural obligation under Article 2 and 3 under Article 3 to investigate complaints of ill treatment. It was in Asenov in Bulgaria that the court first articulated this procedural obligation. And then, of course, as in principle, the facilities in which minors are detained must be appropriate to their condition and to their status. Now, it is fairly well established that when Strasbourg examines cases concerning the detention of migrant children, it tends to do so, as was mentioned earlier, through the lens of Article 3, the prohibition of torture and inhuman and degrading treatment, through Article 5, on the right to liberty and security, and through Article 8, on the right to respect for privacy and private life, family life. And whilst I have concerns and continue to have concerns about the level of protection which the court affords to asylum seekers and migrants in general, it has to be recognised that obligations are imposed on states, more particularly when it comes to migrant children. And the 2007 case of Majeka versus Belgium, known as the Tabitha case, was the catalyst for change in this regard. Now, who would think, you might ask, of taking a 5-year-old child in an airport, taking her away from the adult with whom she was travelling, putting her into an adult detention centre or prison for 2 months, keeping her there, and then sending her back on a plane to the Democratic Republic of Congo, where there was no guarantee that there was anyone there waiting for her, no member of her family? Who would think of doing that to a child? Well, those were the facts that gave rise to the application in the Tabitha case. The applicant's mother had arrived in Canada in 2000 from the DRC, and she was granted refugee status in 2001. She asked her brother, who was a Dutch national, to bring her little girl with her, but he was detained at Brussels airport. He was sent back to the Netherlands, and the little 5-year-old girl was put into a detention centre with adults. There she remained for almost 2 months, and the Belgian authorities, the Belgian court, eventually ordered her release, it being incompatible with the rights of the child. On the same day, the UN High Commissioner for Refugees in Belgium asked that she be given leave to remain whilst her visa application was being processed so she could rejoin her mother in Canada. But instead, on the next day, the child was taken by a social worker, handed over to the police authorities in the airport, and sent back on a plane to the DRC. And as I say, with no guarantee that there was anyone there, no member of her family waiting for her. Now, the case ended up being a turning point, as I said. The court found violations in quite a number of respects. It found a violation of Article 3, firstly, because a child being held in an adult detention centre without counselling or education amongst adults reached the minimum level of suffering required for a violation of Article 3. It noted that there was insufficient legal assistance given to the child and insufficient contact with her mother, and that no steps were taken by the Belgian authorities to avert the psychological harm that was imposed on a child by essentially locking her up with adults for such a period of time. It also noted that her deportation on the plane with adult children, without any person whom she knew, that demonstrated a total lack of humanity. Turning to Article 5, the court found a violation of Article 5 because the conditions of her detention could not justify the deprivation of liberty. And it also noted that there was a complete failure to comply with judicial review proceedings. The guiding principles that emanate from that case can be summarised. The court held that a child's vulnerability takes precedence over all other considerations, including his or her immigration status. The most important consideration is the child's vulnerability. A violation will be found if a legal void exists in domestic law which addresses specifically the rights of a child in custody. When the court is determining the lawfulness of a detention of a child, it must consider not just the lawfulness, but also the appropriateness of the conditions of detention. And a violation will be found if a state is on notice that there's a risk of serious harm being perpetrated on the child, and yet no action is taken to divert that harm. It also signals that distress caused to parents may result in violations of Article 3. And finally, it noted that there is an obligation on state to facilitate family reunification if unaccompanied foreign minors are within their jurisdiction. The next case that we might look at very briefly is the case of Mushkadzieva and others versus Belgium. This was a 2010 case which involved the detention of 5 Chechens, 4 children and their mother, in a Belgian detention centre. And again, the court found violations of Article 3. In this case, the children were detained for 1 month in a closed centre with inapt facilities. But the court had regard to medical reports which demonstrated that there was serious psychological and physical harm being demonstrated, or being manifested, I should say, in the children. Interestingly, when it came to Article 5 in that case, the court didn't have regard to the duration of detention, which was just a month, compared to the previous case, which was a 2-month period. And the importance of the case, really, in my view, is that the court confirmed that the same conditions of lawfulness must be fulfilled for unaccompanied minors and for accompanied minors. So the fact that these children had not been separated from their parents was not decisive. The same conditions must apply to accompanied and unaccompanied children if we're examining the lawfulness of their detention. And essentially it confirmed that the detention of minors in closed centres is prohibited if the conditions are not compatible with the children's needs. In that case, there was no violation of Article 8, the children remaining with their mother for the period of the detention. I think it's interesting to note that in both of those Belgian cases, Article 3 of the Convention on the Rights of the Child, which deal with the child's best interests, and Article 22, the protection of minor asylum seekers, were relied upon in the court's legal reasoning. But Article 37, which provides that the arrest, detention or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest time possible, that was not relied upon in the reasoning. It took another year before that principle became incorporated into the court case law. And that was the case of Rahimi and Greece in 2011. Now, Rahimi concerned the detention and the want of care afforded to a 15-year-old Afghan who was unaccompanied. He was detained in custody for 2 days, and then he was released, essentially to live on the streets. Considering the short duration of the applicant's detention, did not prevent the court from finding a violation of Article 3 because of the dreadful circumstances in which the applicant found himself and because of the extremely vulnerable position that prevailed. Following MSS versus Belgium and Greece, the court concluded that the negligence of the Greek authorities in failing to take adequate care of the applicant, particularly the failure to assign to him a guardian, amounted to a violation of Article 3. It also found a violation of Article 5, and it recognised that, yes, there was a law permitting the detention of the applicant, but that this law had been applied in an automatic manner, without any regard to the specific circumstances of a 15-year-old boy who was unaccompanied and who was in such a vulnerable position. The court said noted the authorities failed to take any regard as to what was in the best interests of the child and whether the detention in question was used as a measure of last resort. It, in fact, doubted that the Greek authorities had acted in good faith in detaining the applicant, and it found a violation of Article 5. It also found a violation of Article 5.4 because of the failure in practice of the applicant to have any means of challenging the lawfulness of his detention. So that even though a document was handed out telling him that it was possible so to do, it was in a language that he couldn't understand. The applicant had also been registered as accompanied when in fact he wasn't, and he didn't have a guardian, so there was no practical means for him to challenge his detention. I looked very briefly at a case which didn't involve a minor, but did involve a very vulnerable young person who was being deported back to the Cameroon, and its interest lies more, for our purposes today, in the fact that in finding a violation of Article 5, the court seems to bring into its case law this less drastic alternatives measure, the test of the least drastic measures, as it were, and detention with a view to deportation must always be closely connected with the ground of detention. There was a violation in that case because of the fact that there was a long gap between the making of the Rule 39 order, because Rule 39 was applied in that case by Strasbourg, and the ultimate release of the applicant. Moving on then, with the case of Popov and France in 2012. This was a case which involved a young married couple from Kazakhstan and their 2 children, a 5-month-old baby and a 3-year-old little girl. And they were detained in an adult detention centre for a period of 2 weeks. They'd been taken back and forth to the airport. Their deportations hadn't proceeded on 2 occasions, and ultimately, the family actually was granted refugee status. But the applicants complained then about their detention during this 2-week period. And when it came to the detention of the children, the court noted that, they were detained in an adult centre, there were very few facilities, there was a heavy police presence, and fundamentally it was incompatible with their rights, with their children's rights under Article 3. They were exposed to a situation of heightened vulnerability, causing inevitable harm. It found a violation of Article 5.1f for the children, because once again the domestic authorities did not assess the individual circumstances of the children, and there was no verification before the court that detention was indeed the measure of last resort, that this had been even thought about by the French authorities. Again, a violation of 5.4 in that case because of the legal limbo that existed in the law. Whilst there was an order directing the detention of their parents, there was no provision, no order directing the detention of the children, and therefore, by implication, there was nothing to challenge. There was no order that they could bring before a court to challenge. And a violation of Article 8 was found on the basis that the detention of this family was not necessary. There was no risk of absconding. There was no pressing social need. Interestingly, in Papa versus France, the court relied considerably upon a lot of international documents and reports and instruments talking about the measure of last resort test, particularly in finding a violation of Article 8. And then if we move very briefly, as was mentioned earlier by the Commission, the cases last year of AB and others versus France and a whole series of other cases concerning the same issue. What is important about this case, I suppose, and this series of cases, is that the measure of last resort was finally incorporated into the Convention. In finding violations of Article 3, the court noted that the detention centre in question, if I can put it kind of colloquially, it wasn't bad. The facilities were appropriate to the children. But what the court pointed out was that the conditions inherent in detention centres in themselves, those conditions are a source of anxiety for children, and that level of anxiety for a young child reaches the minimum level required to find a violation of Article 3. So again, as somebody mentioned this morning, it's as if the issue is being closed further and further. In the beginning, it was just that the conditions had to be compatible with their needs. Here we have a case where, yes, the conditions they're okay. They probably have the playground and their other conditions, but then just being held in a detention centre in itself becomes a source of anxiety. Now, on Article 5, the courts found a violation. The parents quite reasonably refused to be parted from their children, and for that reason the court said that the detention in principle was not contrary to domestic law. However, where children are present, administrative detention must be a matter of last resort, and there was no verification that this was so in this particular case. So if I can summarise very briefly, a failure to protect children will give rise to a risk of violations being found. Extreme vulnerability, that takes precedence over all other issues. No legal voids in the legislation will be tolerated. Detention is prohibited if conditions are incompatible with children's needs, and then even if compatible, those conditions can be a source of anxiety for children. International obligations must be reflected in domestic policies, and detention must be a measure of last resort, and alternatives have to be examined if a violation of Article 8 is to be avoided. Other issues may come up in discussion, but for now my time is up. Thank you very much.
Thank you, Anne. And now I would give the floor to a representative of the Committee of the United Nations on the Rights of the Child, Professor Kirsten Sandberg.
Thank you very much, and I would like to start by thanking you and thanking the Czech chairmanship of the presidency of the Council of Europe for convening this important conference and for inviting me to speak on behalf of the Committee on the Rights of the Child. Actually, the committee is in session in Geneva right now, so I'm going to take all the conclusions and the discussions from this conference directly back with me and to feed into the discussions that we have at the moment in the Committee on the Rights of the Child. So I'm going to talk about the committee's work in this area. First, we had general comment number 6. I'm coming back to all of this, so this is just an overview of what we've been doing. General comment number 6 from 2005, which deals with treatment of unaccompanied and separated minors outside their country of origin. Then there was the Day of General Discussion in 2012 on the rights of all children in the context of migration, Days of General Discussion is a kind of big conference that the committee convenes on important topics. And the committee had seen through its work with reviews of state party reports on what they are doing under the convention, that this was really an important topic to discuss. At the moment, we have a joint general comment which is in development together with the Committee on Migrant Workers. It will be ready, I think, at the beginning of next year, or at least sometime during the first half of the year. And also we have the concluding observations to states when we are doing reviews of their reports under the Convention. Just first, I'd like to mention the issue of age, because some states tend to not remember that children are children all the way up to 18 years, to the age of 18. So they are protected by the Convention on the Rights of the Child. Even if they are 15, 16, 17, they are not to be treated as adults, even if they are approaching 18. Then, what is detention under the Convention on the Rights of the Child? In the Day of General Discussion, it was defined as any custodial setting from which he or she is not permitted to leave at will. And this means that it doesn't matter what it is called, what name you put on it, as long as it is a place where the child is not permitted to leave at free will, it is to be termed detention in this setting. Or not only in this setting, but in all other settings as well, I should add. Then to Article 3, which we have already touched upon in other of the contributions here. It does say that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. So it is a strong obligation because it says shall be a primary consideration. And primary consideration means that it shall have great weight. It cannot be on the same line as all other considerations in various circumstances. So it is very important to undertake a best interests assessment and a best interest determination in immigration cases concerning children. The committee has developed a general comment number 14, on best interests, which does not directly relate to immigration cases, but it's general, but it gives quite a lot of input into how to make this best interests assessment and determination, and what procedures that need to be in place in order to uphold this important rule, this right of the child to have best interests as a primary consideration in all decisions. And I think it's important to add, I'm not going to go into in detail this general comment, but it's important to add that Article 3 applies, of course, at the individual level, as I think we all know, when it's regarding in decisions regarding a specific child. But it also applies at the general level when states are developing the arrangements for children. And that, of course, includes what kind of placement to provide children with, and whether they are to be detained or not. That has also to be at the general level. It has to be, this has to be done with best interests as a primary consideration. So, primary consideration should be given to the best interest of the child in any proceeding which might result in the child's or their parents' detention. It is in this respect also important to remind of the right to development of the child under Article 6, which is a separate right and just as strong as the best interests. It's a right to development in all aspects, psychological and social and physical, mental and spiritual. And it's important to have this in mind in dealing with best interests in immigration cases. This is actually also one of the general principles of the Convention. Then to CRC Article 37, which is the other important provision that we've already heard a little about before from other speakers. It reads, "No child shall be deprived of his or her liberty unlawfully or arbitrarily. The arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate period of time." So, do these provisions of the CRC allow for immigration detention of children? What has the committee said? Is it acceptable to detain children in this context? In general comment number 6, which is on unaccompanied or separated children, we say that they should not, as a general rule, be detained. This is, it says as a general rule, it's not a categorical position in this one. But then, in addition, the committee says, detention cannot be justified solely on the basis of the child being unaccompanied or separated, or on their migratory or resident status or lack thereof. So these are quite clear statements on the position with regard to unaccompanied or separated children. What about families then? Then to the day of general discussion, and this is the statement which is most often quoted from the committee, and I'm happy to hear that it's used by other human rights people who are into this area. We say that the detention of a child because of their or their parents' migration status constitutes a child rights violation and always contravenes the principle of the best interests of the child. And secondly, states should expeditiously and completely seize the detention of children on the basis of their immigration status. So looking at the first bullet point, when a child is detained with or without his or her family because of his or her migration status, it actually means that the best interests has not been a primary consideration, because best interests cannot be properly taken care of if a child is detained only because of the migration status. But actually, what we do say in this picture is the detention of a child because of their or their parents' migration status constitutes the child rights violation. What then? Are there other reasons that may justify detention after all? We hear often, and it has been mentioned here before, that protection of the child from trafficking or other forms of exploitation is, or it is said by states to be a valid reason for justifying detention. We've been discussing this in the Committee on the Rights of the Child, and it's really hard to find examples where it is necessary to detain children because of their need for protection, because there are so many other avenues that the states may use in order to protect children. They don't need to be detained for that purpose. I'm not going to go into the details about this, but this is what is going to be discussed mainly tomorrow, as far as I understand. But it's a slippery slope to say that protection of the child from trafficking or other forms of exploitation is a justifiable reason for detaining children. Because once you say that, states will use this as an excuse, or at least a ground, for having as a general rule that children need to be detained because they are at risk of being trafficked, especially those that are unaccompanied. Other reasons for justifying detention of children, I have not actually been able to think about any other reason which could possibly be in line with children's rights. So what should states do instead? Again, I'd like to refer to the Day of General Discussion in 2012. States should adopt alternatives to detention that fulfill the best interests of the child through legislation, policy and practices that allow children to remain with family members and be accommodated as a family in a non-custodial, community-based context. So this is not only about unaccompanied children, this is also about whole families. So detaining the parents, and if states see a need to detain parents, this is not a justification for detaining children. But as long as children have the right to be with their families, then it means this is also not a justification for detaining parents. So states have to find a different solution when it comes to families with children. And there are alternatives. And it's very easy for states just to say that there are no alternatives, but this is what we really need to explore and to develop. And states should always use the least restrictive means necessary. I would like to refer now to some concluding observations to various countries. With Germany in 2014, the committee had a concern that custody pending deportation imposed on children could last up to 18 months. And we said, which is a direct contravention of the right of the child to have his or her best interests taken as a primary consideration. And we recommended Germany to ensure that detention of asylum-seeking and migrant children is always used as a measure of last resort and for the shortest appropriate time. I must say I'm not so happy about this recommendation because it mentioned this as the shortest appropriate time and measure of last resort. It doesn't say that it should be completely abolished. I think the reason for this may be that detaining children for up to 18 months is in itself so terribly long. It's an extreme length of detention. And I would say that in this case, the committee didn't really take a position on whether it's generally okay to detain children for this reason of deportation. To France in 2016, the committee recommended that the state party should adopt the necessary measures, including those of a legal nature, to avoid the detention of children in waiting zones through increased efforts to find suitable alternatives to deprivation of liberty and place children in appropriate accommodation. The committee had, of course, then been concerned about the number of children subjected to administrative detention, most of them in Mayotte and often in waiting zones or airports or hotels. To the UK in 2016, the committee actually welcomed the UK's decision of 2010 to end the detention of children for immigration purposes. But the committee was concerned that children could be still detained. And then the simple recommendation was for the UK to cease the detention of asylum-seeking and migrant children. To the Netherlands, in 2015, the committee said that they should avoid detaining children and families in reception centres with limited freedom of movement and ensure that their living standard is suitable. I'm not going to touch on the conditions inside the detention facilities because I see my main point here as being that they should not be detained. Bulgaria, 2016, the concerns of the committee was that children continue to be detained and in exceptional circumstances for up to 3 months. The committee was also concerned about proposals to detain families in closed reception centres to ensure family unity without due regard to best interests and development. And the committee recommended to Bulgaria to avoid any form of detention of asylum seekers under the age of 18 and families with children and consider all possible alternatives, including unconditional release prior to detention. I think we are very clear and categorical in this instance as well. To Hungary, we said, I don't have a picture on that the country should ensure that asylum-seeking, unaccompanied and migrant children are not administratively detained under any circumstance. So this one that I have up here is a bit more detailed and in a way better, but it says more or less the same thing, I would say. Estonia in 2017 was recommended to prohibit the detention of refugee and asylum-seeking children. And then the same as was said to Slovakia, The concern to Slovakia in 2016 was that asylum-seeking families with children are being systematically detained for lengthy periods in highly unsuitable conditions. And Slovakia was recommended to expeditiously and completely discontinue the detention of children on the basis of their parents' immigration status and provide alternatives to detention that allow children to remain with their family members and or guardians in non-custodial community-based contexts. So summing up what I've been saying, detention of children should never be based solely on their or their parents' immigration status. And this, I think, is necessary to add to many European countries. This includes the stage where their asylum claim or their application for residence has been rejected. So they are waiting to be returned from the country. This is also that is also an immigration status, and they should never be detained solely for this reason. Alternatives must be developed that allow children to remain with their family members in non-custodial, community-based contexts, including when they are waiting to be returned. And there are such possibilities, such alternatives, and they really have to be explored, as we are going to see later during this day and tomorrow. Thank you so much.
Thank you very much indeed, Professor Sandberg. And now it's the turn of Romina Sijniensky from the Inter-American Court of Human Rights in San Jose de Costa Rica. Please, Romina, take the floor and tell us about what is going on in the Western Hemisphere.
Thank you. So there is momentum worldwide to end child detention for migration purposes. This conference certainly constitutes a milestone opportunity to advance in the understanding of the scope and implications under contemporary international law of the widespread call for the non-detention of children in the context of migration. The aim of my contribution is to share the standards set forth by the Inter-American Court of Human Rights, that's the regional tribunal for the protection of human rights in the Americas. I take this opportunity to express my gratitude to the organizers, to the Czech Republic that has the chairmanship of the Committee of Ministers of the Council of Europe, and to the Ministry of Justice, and of course to Schorm and all his team. In particular, I want to highlight the comparative approach endorsed by this panel, which I hope will favor a constructive dialogue between the diverse and interrelated systems for the protection of human rights. It is an honor also to share this panel with you all. So I will focus on Advisory Opinion 21 of 2014, which was a result of a request presented by the states of Argentina, Brazil, Paraguay, and Uruguay for heightened standard setting to protect the rights and guarantees of children in the context of migration and/or in need of international protection. Such requests sought to move towards the inclusion of a child-centered approach in the migration laws, policies, and practices. When in 2014 the court issued this opinion, a humanitarian crisis was at place, with unprecedented escalating numbers of children moving alone in our region. Mainly, children coming from the northern triangle of Central America. This is El Salvador, Guatemala, and Honduras, and going through Mexico to the United States. In 2014, the number of children apprehended by Mexican migration authorities, as well as US Customs and Border Protection, had more than doubled from the previous year. Just to give you some figures. In 2013, in the fiscal year 2013, 20,805 children from these three countries alone were apprehended in the United States. And in next year, in 2014, 51,705 children from these three countries were apprehended in the United States. You see, more than double. In Mexico, in total, the number of children in those years that were apprehended were 9,630 in 2013 and 23,986 in the following year. Migration and displacement patterns in the Americas are, however, not unidimensional. Migration and displacement is multifaceted, so that most of the time it is possible to identify combined causes which, added to the risk and harms endured in the route, produce a complex and challenging context of mixed migration flows. Although traditional causes for migration consist primarily of socioeconomic factors, poverty, and family reunification, these were still present, hefty reasons triggered the accelerated increase in the numbers of unaccompanied children. Children testimonies show that they were also fleeing from gun-related violence, such as forced recruitment, extortions, and sexual harassment, as well as other forms of violence in the home or with regard to discrimination on account of sexual orientation or gender identity. The voices of children on the move are a powerful reminder of the human dimension of the harms and suffering they endure in countries of origin and on the route, as well as on the noxious, long-lasting effects that detention provokes on their physical and mental well-being. It is hard for children to understand why they are being incarcerated instead of receiving the protection pursued when initiating such an extremely dangerous journey. In this context, a key ruling contained in Advisory Opinion 21 of 2014 refers to the non-deprivation of liberty owing to the irregular immigration status of children. The requesting states had set their consensus position on the need to affirm an absolute prohibition of detention of children for migratory reasons, which was followed by an extensive process of discussion with various states, international organizations such as UNHCR, the Office of the High Commissioner for Human Rights, UNICEF, and IOM, as well as national human rights institutions, civil society, and academic centers. In its assessment, the Inter-American Court conducted a necessity and proportionality scrutiny. While the Court was aware of the legitimate aims and concerns of states in border management and immigration proceedings, it found that the detention of children exclusively for migratory reasons exceeds the requirements of necessity and would therefore constitute an arbitrary detention. Thus, the Court was of the view that there are other less severe measures that could be appropriate to achieve such objectives and at the same time satisfy the child's best interest. In this regard, the Inter-American Court called upon states to treat children on the move first and foremost as what they are, children, and to prioritize a rights-based approach that focuses on the care and well-being of the child through appropriate child protection systems. The protection and comprehensive development of the child should therefore prevail over any consideration of nationality or immigration status. Furthermore, the Inter-American Court delved into the travaux préparatoires of the Convention on the Rights of the Child. It concluded that the principle of ultima ratio, the last resort test, endorsed in Article 37b of the Convention of the Rights of the Child, is not applicable in the arena of immigration procedures, as it is in regard of juvenile justice. Additionally, the Court noted the different procedural purposes between criminal and immigration proceedings and held that infringements concerning the entry or stay in one country may not, under any circumstances, have the same or similar consequences to those derived from the commission of a criminal offense. Consequently, the Court concluded that states may not resort to the deprivation of liberty of children as a precautionary measure to protect the objectives of immigration proceedings, nor may states base this measure on failure to comply with the requirements to enter or stay in a country, on the fact that the child is alone or separated from his or her family, or on the objective of ensuring family unity, because states can and should adopt other less harmful alternatives that at the same time protect the rights of the child integrally. With regard to the best interest argument, even if critical in overcoming detention practices, the court was aware that it can also potentially be used in a pernicious way to justify child detention on the grounds of their own protection or even on the basis of family unity. However, a proper understanding of this principle should inevitably lead to the conclusion that detention will never abide by the child's best interest. Following this line of reasoning, the Inter-American Court went into limiting the scope of the state's response, taking into account the particular situation of the child. In cases where children are unaccompanied or separated from their family, the court found that the deprivation of liberty is inappropriate, because states should, as a general rule, adopt measures of special protection based on the child's best interest through referral to child protection systems. This approach obviously imposes, at least in the Americas region, other challenges that concern the level of adequacy of such systems to the exigencies of the Convention of the Rights of the Child. Even if I will not deal with this aspect in my presentation, I think it is important to keep it in mind. So the court highlighted the fact that any measure adopted must represent an alternative that is different in material and qualitative terms to a deprivation of liberty in closed center, giving priority to a community-based management that is adapted to child's special needs. Let me insist on this point. The key aspect to evaluate whether a measure entails or not a deprivation of liberty, and I think also my colleague from the CRC said it, is not whether or the name that the authorities give it in practice or in internal law. This, as derives from international human rights law, the particular element that allows a measure to be identified as a deprivation of liberty is the fact that the child cannot or is unable to leave or to abandon at will the facility where he or she is placed. Hence, the use of euphemisms does not exempt states from their duties under international human rights law. The court, however, acknowledged that in certain circumstances it is necessary to provide shelter to migrant children, either for a short period of time or as long as necessary to resolve their immigration status or their international protection needs. In such case, reception and care arrangements should cater for the comprehensive development of the child. As a result, the court established minimum conditions or requirements that must be met by facilities designed to accommodate child migrants, whether state or privately run, in order to ensure the protection of their rights. Implementation of proper reception and care arrangement conditions has proved, as it is the case of Mexico that will be shared tomorrow, that favor that children remain in the system until a determination of their proceedings is adopted. So good reception conditions and favoring the protection of the rights of the child favors that they remain in the system, they do not abscond until the determination of the proceedings. A crucial challenge that arises next is a situation of accompanied children, as the solutions are generally envisaged from an adult perspective. Usually, the need to maintain family unit is used as a basis to curtail their liberty and affect other rights, such as personal integrity, but also access to education or health care. Instead of prioritizing the rights of the child, they become invisible. The Inter-American Court's position with regard to such situations, that is when children are with their families, was that the need to keep the family together is not a sufficient reason to legitimate or justify a deprivation of liberty. In this regard, the court gave due consideration to the detrimental effects such measures entail on the emotional development and physical well-being of the child. When the child's best interest requires keeping the family together, the court was of the view that the imperative requirement not to deprive the child of his or her liberty extends to her or his parents. So it's the child that attracts, not the adults. In such cases, authorities need to search for alternative measures to that of detention of the whole family, so as not to impose an excessive restraint on the rights of the child. For example, reporting at regular intervals to the authorities, reception in open facilities, or at a designated place within the community. As the court posed it, evidently, this entails a correlative state obligation to design, adopt, and implement alternative measures to close detention centers in order to preserve and maintain the family unit and to promote the protection of the family without imposing an excessive sacrifice on the rights of the child by deprivation of liberty of all or part of the family. Finally, I would like to mention that in order to ensure the non-detention of children in the context of migration and the effective protection of their rights, appropriate identification and referral mechanisms or procedures should be put in place. For the court, the protection measures should be implemented by a competent authority, let it be administrative or judicial, in a procedure which complies with the specific minimum guarantees and should be based on an individual assessment and the best interests of the child. So to sum up, I would like to highlight the main points that arise from the ruling of the Inter-American Court, which, as I said, outlaws migrant child detention. In first place, the court said or interpreted that the last resort clause is not applicable to the sphere of children immigration detention. The consequences for infringing the requirements for entry or stay in a country cannot be equal or worse than the situation of children in conflict with the law. Second, child detention will never be an option that satisfies the best interests of the child. Third, child detention based on their migratory status is unnecessary and would thus constitute an arbitrary deprivation of liberty. Four, family unit does not constitute a justified ground to detain a child. In this case, the parents or other relatives should be accorded alternatives to detention. 5, states should arrange appropriate open reception and care arrangements that, as UNHCR framed it, and today it was also cited, that do not constitute alternative forms of detention. After the advisory opinion 21 was delivered, the representatives of the OAS member states at the General Assembly welcomed the initiative of the requesting countries and described the document issued by the court as appropriate, given the challenges currently faced in this area. They reiterated the relevance, applicability, and vision contained in this document. They also noted the importance of taking into account the contents of the advisory opinion for countries in the region to adopt their legislation in accordance with its terms. Indeed, mainstreaming in law the prohibition of detention of children in the context of migration constitutes the first step towards the eradication of child detention practices. In our region, several countries have incorporated in their normative frameworks provisions for the non-detention of migrant and asylum seeker children. Examples are Nicaragua, Panama, and Venezuela. In terms of implementation of the advisory opinion standards, I can share 3 recent legislative experiences. In 2015, Mexico enacted the complementary regulation for the General Act on the Rights of Children and Adolescents. In this regulatory normative, Mexico expressly incorporated in law the non-detention rule in the following terms. It's Article 111. At no time, migrant children or adolescents, whether or not traveling in the company of an adult person, shall be deprived of liberty in detention centers or in any other immigration detention center. Of course, the issue of how this prohibition was implemented in practice is very, very crucial, and it will be addressed in another panel, so I will not delve into this issue. Similarly, at the beginning of this year, 2017, Ecuador enacted its Human Mobility Act, which expressly established a prohibition on detaining children for administrative immigration offenses, as well as a prohibition on detaining their parents based on the exigencies of the best interest of principle and on the right to family unit. Also this year, 2017, Brazil passed a new Migration Act, and it also established that no one shall be deprived of his liberty for migratory reasons. In conclusion, although effectiveness in practice obviously plays a central role, I consider that crystallizing in law the non-detention of children rule will ensure states compromise on the issue and provide in the long term with an enduring guarantee against regressive practices and against deprivation of liberty. So to close, I would like to thank you once again for the interest in sharing the standards developed by the Inter-American Court. Standards that, in my view, constitute groundbreaking contributions towards the consolidation of a rule of international law that calls for the compromise of all states to put an end to child detention for immigration control or deterrence, and also to take all necessary steps in law and in practice to achieve so. As I said in my introduction, I trust that this conference will have a significant role in order to effectively stop child detention in the context of migration. Thank you for your attention.
Thank you very much indeed, Romina, for this contribution. And now I turn to the European Commission. So that was the American perspective, and now the perspective of the EU. Ms. Tuite, you have the floor.
Thank you, Vit, and thank you to the Czech Ministry of Justice for hosting this event. It is really timely and very important. So I have the rather lovely task of just setting out briefly what the EU standards are relating to child immigration detention. So basically, there are four pieces of legislation: the Reception Conditions Directive, the Asylum Procedures Directive, the Dublin Regulation, and the Return Directive that cover all this. Under the Reception Conditions Directive, an applicant may only be detained based on an individual assessment if other less coercive alternative measures cannot be applied effectively. And I think when we're looking at all these laws, we really need to think about what it means for an 8-year-old who is with his family, or Amira, a 16-year-old unaccompanied child, to make sense of these laws. Interestingly, also, the Reception Conditions Directive says that rules on alternatives need to be set out in national law. There are 6 grounds for detention in the Reception Conditions Directive. I know you read them there. So detention should only occur under certain circumstances. And then just a quick look at Article 11. If we consider that all children in migration have suffered some degree of trauma, let's remember that health, including mental health, shall be of primary concern. So we have provisions relating to applicants in general. Then for children, the law clearly states that children should only be detained as a matter of last resort. So that seems to imply that you need resorts 1, 2, and 3 before that. And after it has been established that other less coercive alternative measures cannot be applied effectively, detention shall be for the shortest period of time and efforts shall be made to release detained children and place them in suitable accommodation. Somehow we don't hear so much about efforts to release children in detention. Then, when it comes to unaccompanied children, there's an extra safeguard. Unaccompanied children shall only be detained in exceptional circumstances, and again, all efforts should be made to release children. They must be detained separately from adults, and of course, over the last couple of years, we've heard of cases where children have been randomly attached to adults whom they don't know and detained with them. I'd just like to, when someone is in detention, there are provisions around the information they should have and the access to counselling and things like that. In all areas relating to the migration policy crisis, we have seen huge gaps in information to children. So in detention, we can be sure there are gaps there too. In the asylum procedures directive, just note that there are provisions on advice and counselling. Again, no one should be held in detention for the sole reason that he or she is an applicant for international protection. We have provisions on access to judicial review. Then when it comes to the Dublin regulation, there's provisions around the risk of absconding, but also on the basis of an individual assessment, proportionate and less coercive alternative measures. Again, detention shall be for as short a period as possible, and the conditions around detention are regulated in the Reception Conditions Directive. When it comes to return, and Kirsten reminded us all that the return context is very much part of immigration. The provisions are again on the risk, around the risk of absconding or where somebody avoids or hampers return preparation. Extra safeguards for children, whether they are unaccompanied or with their families. Children shall only be detained as a measure of last resort and with the shortest appropriate period of time. And families should be in adequate and separate accommodation. When children are detained, there are provisions around their conditions. But most importantly, when we come to the best interests of the child, we talk a lot about it. The best interests of the child shall be a primary consideration in the context of the detention of children pending removal. We hear that detention is never in the best interests of the child, so there's a lot of ambivalence and ambiguity in the way we interpret laws and what we do about alternatives. In every piece of law, we talk about the best interests of the child, but what does it mean in practice for individual children? I wonder. Thank you.
Thank you, Margaret, for this short contribution. And now we can give the floor to Ms. Maria Rossidi, who is a member of the Committee of Experts on Administrative Detention of Migrants. Yes, this is the tool for handling the PowerPoint presentation. Maria, can I give you the floor?
Thank you, Chair. On behalf of CJDAM, I would like to thank the chairmanship of the Czech Republic for inviting us to this conference and for giving us an opportunity to present our work, and but also to listen and learn. There are many CJDAM members here. As you all know, administrative detention is widely applied in all European states. As the many monitoring bodies of the Council of Europe have repeatedly reported, such as the CPT, the Special Representative on Migration, have reported on sometimes appalling conditions of detention. It is also a fact that legal provisions concerning administrative detention and standards are scattered here and there. In this context, the Council of Europe has established a committee of experts, CJDAM, I will refer to it as CJDAM here afterwards, to codify the existing international standards on the conditions of administrative detention of migrants. Just a few words on the background. The Parliamentary Assembly of the Council of Europe adopted a resolution in 2010. CPT has issued many reports and recommendations concerning administrative detention, but it was for the first time the idea of a codification was proposed in 2013 by the European National Preventive Mechanisms. A feasibility study was conducted, and then this idea of a codification was adopted by the Secretary General of the Council of Europe in his first report on the state of democracy, human rights and the rule of law in Europe. To cut the long story short, a committee of experts was established under the authority of the Committee on Legal Cooperation of the Council of Europe. The mandate of the committee is to produce an instrument of codification of existing international standards relating to the conditions in which migrants are to be held in closed administrative centers and, as appropriate, in other places of non-penal detention in the form of a recommendation of the Committee of Ministers. What is important to note is that we codify existing international standards. We are not allowed to create new standards, and moreover, the grounds of detention are not included in the mandate of CJDAM. CJDAM is composed, all member states may appoint experts. Usually 20 to 23 experts participate from all geographic areas of the Council of Europe, and most importantly, from all countries with increased migration flows, such as Greece. Moreover, various Council of Europe bodies participate: the European Court of Human Rights, the Conference of INGOs, CPT, CEDEDH, also the bodies of the European Union participate, such as the European Commission, FRA, UNHCR, the Office of Democratic Institution of Human Rights of OSCE, IOM, observer states, etc. What have we done so far? We have prepared the first draft of the codifying instrument, and we have submitted it to public consultation. We had a hearing of civil society and other key stakeholders in June. All participants welcomed this initiative, but also raised some concerns. Now we are starting the second reading of the document, having in our hands the results of the written consultation, a quality check prepared by our consultants, as well as a child's rights analysis, which was issued just on Thursday, from the Children's Rights Division of the Council of Europe. Concerning the sources of codification, of course, we are based on International Human Rights Convention, EU law, the European Court of Human Rights jurisprudence, recommendations and guidelines of various international organizations and bodies, including CPT standards. These are the chapters of the codifying instrument that we have drafted so far. We have decided not to have a specific chapter on vulnerable groups, as was our initial intention, but to have various provisions on vulnerability issues, and especially children, in all chapters of the instrument as appropriate. And now I come to children. I have to say that concerning children, we have the most lively discussions in the group. Our discussions evolved around the topic of this conference. Is there an absolute prohibition of the detention of children, or are we moving towards such a prohibition? At the moment, the document that we have drafted stipulates that children shall not be held in administrative detention except as a measure of last resort and for the shortest possible period of time, and after having established that other, less coercive alternatives cannot be applied effectively. All efforts shall be made to release the detained children and place them in accommodation suitable for children. Of course, there are various other provisions in the document concerning children, such as the best interests of the child in all actions concerning detained children, a provision on age assessment procedures establishing a presumption in favor of minority, a provision on family tracing concerning unaccompanied minors, the appointment of a guardian, and others. And I will come back to issues concerning children a little bit later, but allow me first to present a few difficulties that the codification exercise presents. The codification exercise is not a copy-paste exercise. First, we have to identify the standards that we are going to codify. If there are no standards concerning administrative detention per se, then we have to identify the standards in relevant areas of law that could apply by analogy. And then we have various issues arising. Which soft law standards should we codify? As we heard, CPT standards are included in our codification process. So we are paying attention to what the international bodies, apart from the legal provisions of the conventions, what the international bodies have to say. And what about EU law, for example? Should it be part of the codifications, taking into consideration that it's only binding for EU member states? And then we have even more difficult questions, such as if we have to take into consideration provisions on the conditions of criminal detention. Do they all apply by analogy? Of course not, it's the answer, but how can we choose which provision to apply and which provision not to apply? And if we omit certain provisions, then will this be interpreted that they were intentionally left out? And the most important thing is if this would be detrimental or in favor of detainees' rights. And then we have the issues, certain issues concerning our mandate, concerning the scope of application of the instrument. The mandate of CJDAM provides that the codification provides for the codification of existing standards on the conditions of detention in closed detention centers and, as appropriate, in other places of detention. So, should the scope of application be defined ratione loci or ratione materiae? And what could those other places of detention be? We have this fundamental provision, a very basic provision, that detainees should be people who are detained should be detained in specifically designated centers to that end, not in prisons, not in transit zones. If we have provisions on these other places of detention, do we undermine this very basic principle? And how can our instrument be practically applied, since it has so many details about the everyday operation of detention centers? Can this be applied in transit zones or police stations? There were also concerns on the level of protection of the instrument in certain areas, as well as the level of specification of the provisions. Some provisions are establish very general principles, basic rights of detainees, whereas other provisions are referred to the everyday life in a detention center. However, this could also be very useful on states. And finally, and most importantly, should there be provisions on vulnerable groups, such as children? Does this contradict the fact that, as we heard since this morning, vulnerable groups should not be detained ever? And now I come to all these issues concerning children, and I finish my presentation with these concerns. As I mentioned, we had very lively discussions concerning children, and we will certainly continue to have. Can we finally speak about an absolute prohibition of detention? And if such a rule exists and we identify such a rule, then we should not have any provisions on the conditions of detention of children. At the moment, as we heard, the reality is that children are detained. Can CJ Dam disregard this fact and say nothing about the conditions of detention? Won't the absence of such provisions lead to a gap of protection? On the other hand, if we include provisions on the condition of detention of children, is there a risk of normalizing even more detention of children, or a risk of undermining the trend of international law towards an absolute prohibition of detention? As Commissioner Musnik said, there is a trend to end to an absolute prohibition of detention. So if we have such provisions in the document concerning conditions of detention, finally, should there be a reference to the best interest of the child for all actions during detention, taking into consideration that detention can never be in the best interest of the child? Mr. Giacomopoulou said it this morning, and we heard that the Inter-American Court of Human Rights has said it as well. So all these questions have been troubling us and have been highlighted in the process of the consultation process that took place in June. The results of the consultation will guide us in our future work. The parallel work of other Council of Europe committees will guide us. And also the conference that takes place here today will also help us clarify these issues. And I can assure you that me and all the other members of CJ Dam who are present here will follow your discussions with great interest. Thank you very much.
Thank you, Maria, very much for this presentation. It is my understanding that the work of your working group is not easy because you face a great number of very difficult questions. And in order to show that my team is not only for the organization of this conference, but also is heavily involved in the working groups of the Council of Europe, I would now give the floor to my colleague, Petr Konupka, who will add a couple of remarks to the latest presentation. Please, Petr, you have the floor.
Thank you, Vít. Good morning, everybody. My name is Petr Konupka. As it was said, I have the honor and the privilege of being the member of the CJ Dam Expert Committee on behalf of the Czech Republic. And indeed, I need to confirm what Maria said, that the codification is not such an easy exercise as it may seem at the first sight. The specific standards on immigration detention are missing in some areas, and the existing ones are sometimes inconsistent or even contradictory. And furthermore, some standards are applicable only to a certain category of migrants, not to all of them. So the codification is not just putting things together in one document, but also filling the gaps and reconciling inconsistencies between various norms. And this requires really good apprehension of the very essence and mainly of the purpose of most related available standards. And if there are no standards of general principles of international human rights law and their adequate adaptation to the field of the immigration detention. And in my opinion, what is a key consideration in this respect and in the whole codification process is that the ultimate purpose for which the codification was started some 4 years ago is to enhance protection of human rights of a vulnerable group of persons, the migrants. And also the promotion of human rights is one of the key missions of the Council of Europe, which provides the framework within which the codification is taking place. So this purpose of the codification and its purpose clearly indicate this codification exercise is not a value neutral but quite on the contrary, that the emphasis needs to be put on the protection of human rights of persons concerned. So therefore, with this fundamental aspect in mind, the main challenges that have emerged during the consultation process and during the codification process should be addressed. So, for example, as it has been also suggested in several observations submitted during the consultation process, it would be appropriate, firstly, to devote more space and to the alternatives of detention by including, for example, by including more specific, or by including specific substantial and procedural provisions on the issue of alternatives to detention into the codifying instrument. And this would reflect and also highlight the fact that immigration detention is an exception and not a rule. And also this would help to avoid any impression or any impact of normalization of the immigration detention that the codification could eventually bring about. And secondly, it is necessary to ensure that the codification does not contradict any trend that has been emerging in the international soft law, but which has not yet, and I would emphasize, not yet been fully reflected in the hard law. And this is, for example, as it has been mentioned also, the issue of the immigration detention of children, which where the trend is quite clear, but not yet fully reflected in the jurisprudence of the European Court of Human Rights. So to conclude, and this would be my final remark, I think it is very important to keep in mind that the codification does not necessarily mean anchoring the least protective of available standards. And at the same time, the codification must not be detached of its very purpose, which is the protection of human rights of a vulnerable group of persons. Thank you.
Thank you for this contribution to the discussion. Unless there is someone else who wishes to intervene shortly, then we will move to the questions put through Slido, and I can only invite you to vote on the pertinence of these questions, because probably only those which are at the top will be taken. I saw a wish for the floor from Mr. Lewis, I think. I suppose I identify you correctly. And then another gentleman here, and then we'll move to the questions through Slido. All right? Ben?
Thanks very much, and I'll be quick. Ben Lewis with the Office of the High Commissioner for Human Rights based in Geneva. Just wanted to point out something in terms of the international law framework that I don't think has been coming forward so strongly, so just to stress it from the position of the High Commissioner's Office, that the nature of the right to liberty is quite sacrosanct in the panoply of international human rights law, other than perhaps the right to life, which is, of course, once one's life is taken, it can never be gotten back. The right to liberty is similarly very fundamental, and so fundamental that, like the prohibition on torture, for example, the prohibition on arbitrary detention is a customary norm of international law that's non-derogable. It's a jus cogens norm. I think we lose sight of that because in the modern context, of course, detention is sort of becoming the knee-jerk reaction for a number of problems. If it's drug addiction, we put people in prison. If it's vagrancy laws, we put people in prison. If it's low-level status offenses, such as immigration, we put people in prison. And I think we really need to hold sacrosanct the right to liberty, especially in this context, especially because this practice that is, I think Maria said quite accurately, is now extensively used across Council of Europe member states, is a new practice. 50, 100 years ago, this was not an extensive practice. So I think we need to address this both from the sacrosanct nature of the right to liberty and the relatively new way that states are using detention in the context of migration. Thanks.
Thank you for reminding us of that. And then please, would you give your name?
Jean-Michel Condron. I'm from the Conference of the International Non-Government Organization of the Council of Europe. I have questions to all of the speakers. The UN expert talked about the International Convention on Migrant Workers and their families. When I present a draft International Convention on Elderly Citizens before the UN, I really wanted to defend this convention before the Moroccan civil society. Well, somebody from the Moroccan League of Human Rights said, okay, we're willing and ready to defend this project, but you Europeans should start by signing this International Convention of Migrant Workers and their families. Well, I checked, and indeed I checked that no country of the European Union ever signed this convention, and 6 countries of the Council of Europe, Albania, Armenia, Azerbaijan, Montenegro, Bosnia-Herzegovina and Turkey signed it. Well, we, civil society, should probably promote with the countries of the European Union and Council of Europe the signature of this convention. Maybe that would put an end to detention of migrant children. Thank you very much for your question.
I turn to the panelists, whether there is someone who wishes to address this question. Is someone ready to say something about that? Ms. Sandberg?
Thank you. I could just say that the Committee on the Rights of the Child, in all concluding observations, recommendations to states, recommend that they should ratify the Convention on Migrant Workers. Now that we are making this joint general comment together with that committee, we state clearly in the general comment that there'll actually probably be 2 of them, because one on general principles, one on the more specific issues. State clearly that this is all states that have ratified the CRC will be this general comment is directed to all of those states, not only those that have ratified the Convention on Migrant Workers. So at least this general comment will have a much more broad scope or be directed at almost all states in the world, including the issues of detention, which are going to be included. But otherwise, I agree with you. Thank you.
Yes, thank you very much. If there is no one else, then we can have a look at the questions. I think the first question is quite a tricky one. How can a state return families who do not want to cooperate at all if detention is not possible? I think the European Court of Human Rights admitted that a detention for a very short period of time is possible, but I wonder whether there are other panelists who represent other opinions, namely that the detention of children should be banned in each and every circumstance, whether they have an answer to this, let's say, practical question. Yes, Ms. Power-Forde?
Hi. Yeah, I'm just happy to address this question briefly, because I see a lot of people have supported the raising of the question. I think there's a balance there that has to be achieved. On the one hand, certainly under the Convention, there is the right under Article 5.1f to detain a person for the purposes of deportation. I mean, that is clear, and that is something the court cannot ignore. And as you're very familiar with, the court is consistently reminding us, when it deals with detention cases, of the state's right to control the entry into and exit from its borders. That is entrenched in the law. Having said that, there is, of course, this whole question of detaining minor children. And I think, as we have seen, the way the court gets around the lawfulness issue is by looking at the conditions of detention. And whilst it has never said categorically that it is always a violation of Article 3 to detain a child awaiting immigration, it's certainly getting closer and closer and closer to that. I don't think the court can ever make that statement categorically, given the existence of Article 5.1 and given the precise scenario that's presented in this situation. Because if a child who is part of a family and the family has exhausted all remedies and they're found not to be entitled to refugee status or international protection or whatever else, if it has gone through all the remedies and the state then seeks to enforce its right to control its entry into and exit from its borders, then the state has the right to remove that family. But if the family refuses, how do you get the family from A to B, from their place of residence if they're in the community to the airport to board the flight? There is that practical question, and I think it's a choice between, say, leaving them in the community until the very last minute and then taking them up, but that's not great for families either, because suddenly, they don't have much notice, and the night before they're ready to go, they're picked up and they're taken to the airport. And that's traumatizing for a child as well, to be in school one day and out of school the next and on his or her way out. So it is a very difficult dilemma, but certainly under the convention, the European Convention, the right to detain in those circumstances, in those limited circumstances under 5.1f, it's there, but it has to be balanced, of course, by the Article 3 prohibition on degrading treatment. So it's a difficult one. I don't know how to resolve it, but as I say, perhaps one way, it's not ideal, is to leave the child in a non-custodial setting for as long as possible, and at the very last minute, provided the guarantees of the removal directive are in place, then to actually effect the removal. But it's a difficult one to achieve.
I will give the floor to the others as well, but there is another question concerning the case law of the European Court of Human Rights, which is the following one. How can, in the situation that the child's vulnerability takes precedence, how can the court ever find detention solely for immigration control consistent with the Convention? Would you like to expand your previous answer in order to cover this question as well?
Very briefly, the trend, as I have said, is clearly towards finding the detention of a child based on his immigration status in closed centres inconsistent. But as was pointed out, it's inconsistent with Article 3 rather than in itself unlawful under Article 5. The court in the most recent case in AB versus France, on that whole series of cases, accepted that the conditions were appropriate, they were acceptable, but the very fact of being detained created that source of anxiety in the child. So it's coming as close as possible, I think, to saying that in that particular case, the child's vulnerability took precedence over his immigration status. It's as close as it can go, but it's I don't think it will ever, I don't want to preempt the court, obviously, but given the existence of 5.1f and the absolute prohibition on inhuman and degrading treatment under 3, which the court consistently seems to find states are in breach of when they detain a child, I can't imagine the court ever coming out with an absolute statement unless it were to say, henceforth we are going to interpret 5.1f in the light of Article 3, and since Article 3 is absolute, and the detention of a child minor is degrading in itself if the only reason for detention is his status and not his need, for example, if he was, in need of psychological care or whatever. Unless the court were to make a policy decision to interpret 5.1f in the light of 3, then that would be one way in which it could say, yes, the child's vulnerability truly takes precedence over all other considerations. But that's a big leap for the court to take. I don't know whether it will or not.
Thank you for this explanation. Well, to other ladies, how to remove a family which does not cooperate at all with the state's authorities. Would you like to address this issue? I know Mr. Stavros wishes the floor as well. Maybe you can be of help in this tricky situation?
Yes. Thank you very much. I totally agree with what Anne said. We have a very interesting input to this discussion by the Supreme Court of Norway. And the Supreme Court of Norway did not take issue with the fact that children were detained as such in these circumstances, but took issue with the decision-making process. So what the Supreme Court of Norway said is that we should not be asking whether the parents should be detained and then ask whether the children should be detained once we have decided that the parents have been detained. but we should be asking whether the best interests of the child should be taken into consideration in the first place when the decision to detain the parents is taken. So, although we cannot exclude the detention of families in every circumstance, this is also another way of another inroad into the decision-making process to reduce the detention of children.
Thank you. Ms. Sandberg?
Thank you for this last comment. And I would like to add that in addition to the procedural issues, there would also be the question of really having considered alternatives. In the light of the child's best interest, what might be possible alternatives which could be less restrictive than detaining the family? And you mentioned one possibility, that the child could maybe stay out of detention, then the child's right to family life is not complied with at that point in time. But also there are other less restrictive means than detention that would finally end in the family being sent out of the country. But I think these are things that we are going to discuss in more detail tomorrow.
Well, this is true. Thank you. Ms. Sijniensky?
Yes, my answer goes more or less in the same way, in the sense that I think we are so used in some context to detention that we cannot think of other ways, other means. So it seems like just impossible, when it is not. We have some comparative experiences that will come after in this meeting. So I think, yeah, we have to change. It's difficult because it's changing the way we think about it. It's something cultural, and it's something that will take some time to make this change. But I think other possibilities are open. And also, I wanted to say that when deporting a family, you should also take into account the best interests of the child. It's not only if parents should be deported or not, but also, for example, for how long have they been in the country? Were these children born in the country? Is this going to imply a separation, or that children could not, go to school, access education, access health? So I think it's a little bit more complicated than just to say, well, the family or the parents do not want to be deported. So I think the best interest of the child should be like a primary consideration in all aspects. In deportation, when when it's a family, also which are the alternatives? And then this is the most important part.
Thank you very much indeed. Mr. Yakoumopoulos, concerning this question.
Thank you. I would like to speak in French, if I may. I would just like to revert to the question of how can we ensure that a person, for example, a child or a family, will be expelled without having been put into detention, as my colleague, Mr. Stavros, said. I remember Mrs. Stavros said that the CPT, in fact, had met persons, children who were detained upon arrival throughout their stay, whilst their requests were being examined, and just before they were to be sent home. And I fear that the real problem is the in-between period and how to describe it. We can say that an 18-month stay, which is provided for in the European regulations in order to prepare, is intended to, in fact, prepare for the return. But it's very rare that it takes that long, and according to the case law of the European Court, constant efforts have to be made, and that the lawfulness of the detention, in fact, ends when these efforts, in fact, are no longer being made. Therefore, I believe that we should not find ourselves in such a stalemate, because certainly during the return proceedings, somebody has to be put on board a plane, and that's already a form of detention. And we can't just rule out all the different possibilities, but we have to specify under what conditions and for how long this should, in fact, last. I'd also like to say something regarding the question that was mentioned by Bill earlier on regarding total rights. I don't think that Article 5 cannot be derogated from. On the contrary, it can be. It is in urgent cases, and that holds true both as regards the European Convention and as regards the Covenant on Political and Civil Rights. Now, as regards the issue of whether there is a customary law which would prevent the detention of migrant children, I don't think we have reached that far. In fact, there is a convention provision, 5F, which Mrs. Ann Power referred to, but in addition to that, there is also a constant practice on the part of member states, even if it's in fact almost become a continuous administrative practice today, but which exists since the end of the Second World War. I don't know what happened before that, but certainly since the end of the Second World War, there is this practice of administrative detention, including of children, which in fact used to be exceptional, but it's becoming totally normal today. And I think that's the real problem that we need to tackle. I don't think it is a problem which has to do with customary law or convention law. I think we're really speaking about a legal vacuum which the European Court is trying to fill slowly and gradually, but having regard to the limitations imposed by the convention, and again having regard to the limits under international law. Thank you very much.
Following question. In my opinion, the answer is quite straightforward. Some states say that children with family in detention are not in detention, they can leave. What is your opinion? I think the opinion is that it's not like that, it doesn't work this way, but someone from the panel may want to add something, because if the family is detained, then of course the children are not so free to move, even though they can go somewhere else within the framework of some activities proposed in the detention facility. Ms. Sandberg?
Yes, I certainly support what you say. That the child, it's a very formal way of looking at it. If you say that as long as the child can leave the detention center, the child is not detained, and then it's not a problem, because the child still lives in a detention center. And we've heard a lot about the conditions in such centers, and it is a condition of deprivation of liberty of people around, and including the family. And it would definitely be a violation of the child's right to family life if the child could not go outside together with the family. And also on the child's liberty, as you said yourself, it's a restriction when the child cannot move outside without the family. Of course, especially for smaller children, but also for the older ones. Thank you.
Thank you. Then there is a question to Ms. Tuite. Can you give a specific example in which detention of minors as a last resort can be justified? I think this is slightly a question about the justification of the EU directives in this area. Would you say a few words about that?
I think we should take that question from another angle. Are we convinced that all the measures and safeguards are in place to respond to the case of a child unaccompanied or with their family, including proper reception, the early appointment of a qualified and trained guardian, access to information, access to legal counsel, that a child is dealt with in a respectful and honest manner. So if, for example, their claim is unlikely to be recognised, that is dealt with from the get-go with them in an honest way, and their situation is looked at within the constraints, within their own circumstances, and an approach is taken to offer care and protection insofar as they can be dealt with for that case. So if it's known that an asylum claim is highly unlikely to be recognised. They look at what can be done in the time the child is there. If they're going to school, do they get a school certificate, or are they the subject of a dawn raid and they're deported without any papers and so on? So I think by putting more focus on the safeguards up front, it would be better than dealing with this kind of hypothetical question, because I don't know what resorts 1, 2, and 3 are in each case. Thank you.
Thank you. Then there is a question about or whether the Committee on the Rights of the Child developed standards on non-custodial and community-based alternatives to detention. We will speak about alternatives to detention tomorrow, but I wonder whether Ms. Sandberg wishes to say a few words in response to this question.
Well, we haven't really developed any standards on this. I must just say this is the formulation that we use, and then it's up to the states to take it back and in cooperation with NGOs, civil society, develop these community-based alternatives. Thank you.
Okay. Thank you. Then this is probably a question for Ms. Power-Forde, whether the ECHR has determined what are the conditions of detention that satisfy children's needs.
To my knowledge, the court doesn't specify precisely what would be acceptable. It will take each case on a case-by-case basis. It will look at such things as the age of the child, the duration of the period for which the child has been kept in custody, and the general conditions. So it doesn't kind of set down the conditions as, for example, in other Article 3 cases where it says 3 square meters of space is acceptable for a prisoner if detained in a cell. It doesn't give those kind of guidelines when it comes to the detention of minor children. If anything, it would be, I think, raising the flag to say, you know, particular attention must be paid here, conditions must be appropriate, but as we've seen even recently, even where they are appropriate, detaining children in itself gives rise to anxiety, and that is a harm perpetrated upon a child, and it can violate Article 3. So the brief answer is no, it doesn't specify in detail, but it does look at the factors I've mentioned on a case-by-case basis.
Thank you. And the last question which we will take is the one with 9 votes. Is it generally a breach of law if there are no alternatives or they are not used by state authorities to detention of families and their children? So there is agreement on this question. Okay, so it is. The question is yes, it is generally a breach, but some nuances must be added.
It is yes, in the sense that the case law, certainly if the court says you must look for alternatives when it comes to children. I think the question has 2 aspects to it. If there are no alternatives, there should be, and if there are alternatives and they're not being used, then they should be. So in both instances, they should be used, but it's again subject to this problem that we've discussed earlier about the very last minute when somebody is, you know, when a state is entitled to remove somebody, at some point the detention may be permissible, may be lawful, albeit having regard to all of the factors that we must take into account.
Thank you very much indeed. I also think that, of course, it is subject to a case which is scrutinized by, for example, the Strasbourg court. So there it must be made clear the situation, the existence of alternatives in law and in practice. Well, there is a wish for the floor. If you promise to be very short, then I'll give you the floor.
Teff from the International Detention Coalition. Just wanted to link that question back to the question we were discussing about returns, and to the point perhaps made in the first opening session that actually rates of return from detention are not particularly high. And the International Detention Coalition, in its years of research of alternatives to detention in over 60 countries around the world has actually found higher rates of voluntary return from alternatives to detention than from inside detention. Just wanted to make that point. Thank you.
Thank you for this useful addition. I should like to thank the panelists, the ladies who took the courage to speak in this panel about law.